I am going to tell you what nobody tells you about wills. This is not law school theory. This is what I watched happen to real American families during 22 years sitting on a probate bench. Five mistakes. Five mistakes that look like administrative details, but each one can void a will completely. And what bothers me most about this list is that none of these mistakes are buried in obscure case law. They are in plain sight. Any competent estate attorney would have prevented all five in 15 minutes. And yet, I watched the same five repeat themselves for more than 2 decades. My name is Richard Hall. I served 22 years on the bench, presiding over probate, guardianship, and contested estate matters. I retired at 57, earlier than most of my peers. I retired after a case that marked me in a way I cannot describe in any other terms. A woman of 81 years, lucid until the very end, watched her own children dismantle her life in front of a court that was unable to intervene in time. By the time the case reached my courtroom, the assets were already gone. The home, sold. The bank accounts, drained. The restitution proceeding lasted 4 years. By the time it concluded, most of the funds were unrecoverable. I could not repair what had already been lost. I could only enter the order recording the loss. And I understood that day that the American system of elder protection is a promise that arrives late, always late. That was when I started planning my exit from the bench, and that was when I understood that the only truly useful thing I could do with what I had accumulated in those 2 decades was to speak publicly about the mistakes I kept seeing, to speak before the signature, before the loss, before the litigation. I will start with the first mistake. The first mistake is the form of the will. More specifically, it is the misplaced trust in do-it-yourself wills. Most American states recognize 3 categories of wills: the attested will, signed by the testator and witnessed by 2 competent witnesses in most jurisdictions, 3 in a few; the holographic will, written entirely in the testator's own handwriting, recognized in roughly half the states and invalid in the rest; and the nuncupative will, an oral will, allowed only in extremely limited circumstances. Each form has precise requirements, and missing one element invalidates the entire document. In practice, I can tell you with the authority of 22 years reading probate files that the do-it-yourself will downloaded from the internet is a trap disguised as convenience. It works in theory, it fails in practice, because it almost always misses something the state requires and the testator never knows it. Mr. Hubert Markland, 79 years old, retired manufacturing supervisor in a small town in the Midwest. His estate consisted of a paid-off home, a small recreational property, and around $140,000 in retirement accounts. He went online, found a $50 will template, downloaded it, filled it out at his kitchen table, signed it, and asked his next-door neighbor to sign as witness. Just one witness. He believed that downloading from a legitimate-looking website meant the document was valid. He filed it in his desk drawer. When Mr. Markland passed 5 years later, his older daughter brought the document to her brother's attorney. The attorney opened the file and saw the problem immediately. His state required 2 witnesses for an attested will. There was only one. The will was thrown out. The estate passed under intestate succession laws. The intent Mr. Markland wrote out, signed, and dated carried no legal weight whatsoever. I will give you a second case to drive the point home. Mrs. Margaret Tilden, 78 years old, executed a perfectly proper attested will in 2014 with 3 competent witnesses, all properly identified. When she passed in 2022, 8 years later, 2 of the 3 witnesses had died, and the third had moved out of the country and could not be located within the procedural deadlines. Without a self-proving affidavit attached to the original document, the probate court required the witnesses to be located, alive, and available to testify in person. The estate spent 14 months trying to locate the third witness through international service. By the time she finally responded, 2 distant nephews had filed a contest seeking to invoke intestate distribution. The complication cost the heirs roughly 7 years of probate proceedings and approximately $180,000 in attorney fees. The will was eventually admitted, but the time lost during the litigation devoured the estate. The principal residence, with no maintenance and no use during the proceedings, lost roughly 30% of its market value. Property taxes accumulated. Frozen accounts produced no return. That is the invisible cost of poor execution. Even when the will survives, the time of litigation destroys what it was supposed to protect. The solution is straightforward. Have the will drafted and executed by a licensed estate attorney in your state. Use the witness count your state requires. Add a self-proving affidavit. The document then exists in the firm's records, and the witnesses do not need to be located after death. The cost is higher, the procedure is more involved, but it is the only form that survives a serious challenge. Second mistake: undue influence. This is the most painful mistake to explain to a family, because most beneficiaries who exert undue influence are not acting in bad faith. They are acting out of proximity. They care for the elderly person, they are present in daily life, they organize the practical matters, and when the time comes for the will, they naturally offer to help with the logistics. And it is precisely that help that destroys the document later. Undue influence happens when a beneficiary controls the process. They pick the law firm, they retain the attorney, they schedule the appointment, they drive the testator to the office, they sit in the room during the drafting, they sign as witness. Each one of those gestures individually looks helpful. Together, they constitute undue influence under American probate law. Mrs. Victoria Galloway, 76 years old, 3 children. The youngest daughter lived with her in a suburb of a major American city. The 2 siblings lived out of state. In 2019, Mrs. Galloway executed a new will. The youngest daughter coordinated everything. She recommended a law firm where she had contacts. She retained an attorney friend of hers. She scheduled the meeting for a Wednesday morning. She drove her mother to the office. She sat in the room during the drafting. She signed as witness. The will heavily favored that daughter. The principal residence, valued at roughly $600,000, went to her in full. The other 2 children received only modest cash legacies. Mrs. Galloway passed in 2022. The 2 siblings contested. The case came to my courtroom. The record showed everything. The daughter had paid the attorney's retainer. The daughter had recommended the firm. The daughter had served as witness. A neighbor submitted a sworn statement confirming that during the months leading up to the will, Mrs. Galloway never visited her other children alone. Everything went through the youngest daughter. I set aside the will. The estate passed under intestate succession in 3 equal shares. And here is what you need to listen to carefully. I do not doubt that Mrs. Galloway sincerely wanted to leave more to the daughter who was caring for her. The intent was real. The problem was the context, and the context could not be undone after the fact. I also saw the opposite case, and I want to tell it to you so you understand that the only difference is the context. Mrs. Estelle Brennan, 72 years old, wanted to leave the larger share of her estate to the granddaughter who was caring for her. She was guided by an outside attorney chosen without family input. She went to the law office alone in 3 separate visits. She attached to the will a handwritten letter explaining her reasoning, video declarations of intent, and a recent psychological evaluation attesting to full capacity. When she passed, 2 children contested. The litigation lasted only 11 months. There were no markers of undue influence. The granddaughter had no involvement in the logistics. The witnesses were attorneys from the firm who had no connection to anyone. The court rejected the contest. The will was upheld in full. The difference between Mrs. Galloway and Mrs. Brennan was not the intent. Both wanted to favor the person who was caring for them. The difference was the context surrounding the signature. That context is everything. The rule is direct. If you are a potential beneficiary of a will, stay completely out of the logistics. Do not pick the firm. Do not retain the attorney. Do not schedule the meeting. Do not drive the testator. Do not sit in the room. Do not sign as witness. Do not pay the bill. Your good intentions, combined with your presence at every step of the process, become the evidence that destroys the document later. Third mistake: doubtful testamentary capacity at the moment of signing. State probate law requires what is called testamentary capacity at the moment of execution. The testator must understand the nature and extent of the property, the natural objects of the bounty, and the disposition being made. It is not enough to be conscious. It is not enough to recognize family members. It is required to have the cognitive function to grasp what is being given, to whom, in what proportion, and what the consequences will be. When the will is executed during a hospital admission, under the influence of strong medication, or an already recognized late-stage cognitive decline, even if the person seems lucid in moments, capacity can be challenged and proven to have been impaired. And once impairment is established, the will is voided. Mr. Armand Foster, 82 years old, admitted to a long-term care facility for the management of advanced complications, on a continuous regimen of opioid pain medication for chronic pain and benzodiazepines for episodes of agitation. The oldest son arranged for a will to be executed during the admission. He brought in a notary public familiar to the family and 2 witnesses. The document was read aloud at the bedside. The father nodded, signed with a trembling hand, and the document was completed. The will heavily favored that oldest son. It justified the disposition by reference to the year of caregiving during the illness. The other 3 children received only nominal legacies. When Mr. Foster passed 3 months later, the other children contested. The medical expert retained by the court analyzed the medical chart, the morphine and lorazepam doses administered on the day of execution, the nursing notes documenting that the patient was experiencing intermittent confusion and disorientation, the drug interactions. The expert concluded that, at the time the will was signed, the probability of preserved critical judgment was low. The will was thrown out. And here is the detail that strikes me most when I remember this case. The oldest son was, in fact, the one who cared most for his father. Mr. Foster's intent was probably genuine, but the context, hospital, strong medication, medical records documenting confusion. It was a context that no will could survive a contest in. The rule is hard, but it is the only honest one I can give. Make the will at 60, at 65, at 70. Do not wait until 80 with hospitalization on the horizon. Along with the properly executed will, attach a recent letter from a licensed physician documenting full testamentary capacity, dated within 30 days of execution, with an objective cognitive assessment. That letter is the only real protection against a contest based on capacity. I am going to pause here for a moment. If you are still listening at this point, this video matters to you. Do one small thing: subscribe to the channel and leave a comment with the word "understood." That gesture helps deliver this video to other families who need to hear it before they sign anything. Fourth mistake: interested witness. This is the technical mistake that surprised me most the first times I saw it. It involves who signs the will as a witness. In most American jurisdictions, there is a long-standing rule called the interested witness rule. A person who is a beneficiary under the will, or the spouse of a beneficiary, or in many states a close relative of a beneficiary, cannot serve as a witness without consequence. In a number of states, the consequence is what is called purging. The witness's gift under the will is voided. The will may stand for the rest, but the gift to that beneficiary is purged. The case of Mr. Pierce Reynolds illustrates this. 70 years old, retired business owner. His estate consisted of a commercial property generating rental income, the home he lived in, and several brokerage accounts. Mr. Reynolds had a nephew who had grown up almost as a son in his household. When Mr. Reynolds decided to execute a will, he went to an attorney's office and brought witnesses. One of the witnesses was the sister-in-law of that nephew he intended to favor. He saw no problem with it. He believed it was just a formality. The will left the commercial property to the nephew. The remaining assets went to Mr. Reynolds' siblings. When Mr. Reynolds passed, the siblings discovered that the nephew's sister-in-law had served as a witness. They challenged the bequest to the nephew. The court applied the interested witness rule directly. In that state, the rule extended to close relatives by marriage. The bequest was purged. The commercial property fell into the residuary estate and was divided among the legal heirs. The nephew received nothing, even though Mr. Reynolds' intent was perfectly clear. And it was not because of bad faith. It was because of technical ignorance. The sister-in-law fell within the prohibited class under that state's interested witness rule. Nobody checked. The notary did not verify. The nephew did not know. Mr. Reynolds thought he was helping. And that single misplaced signature cost the entire commercial property to the intended heir. State law also bars certain other witnesses. In some states, the notary public who notarized the document, employees of the law firm that drafted it, and individuals lacking legal capacity themselves are all on the prohibited list. The list is technical, and most people, including some less experienced attorneys, are not fully aware of every category. I saw a case roughly 6 years ago in which a will was set aside in part because the second witness, while apparently independent, was the second cousin of one of the named beneficiaries. The familial relationship had to be proven by birth records, and it was. The court applied the prohibition. The disposition to that beneficiary was voided. He lost an inheritance valued at approximately $400,000 because of a witness he did not select, but who happened to be present. The rule is clear. Before you sign any will, personally verify who the witnesses are and what their relationship is to each beneficiary in the document. No family connection within the prohibited degrees of your state. No close effective connection. No financial connection. Ask the attorney how the firm ensures the witnesses meet the state's interested witness requirements. If the answer is unclear, find another attorney before signing. Fifth mistake: joint and reciprocal wills with a spouse. Joint wills are when two people, usually a husband and wife, execute a single document setting out reciprocal dispositions. Husband and wife, sitting together, drafting one document where each leaves to the other, and both sign. It looks like the most natural thing in the world. It looks loving. It looks practical. It is exactly what many older couples believe they should do. And while joint wills are technically valid in many American states, they create irreversible legal problems that very few couples understand at the time of signing. The problem is what is called a contractual element. When two people execute a single document with reciprocal reciprocal dispositions, courts often interpret that as a binding contract between them, not just two individual wills. That means after one spouse dies, the survivor cannot freely change the will, even if circumstances have completely changed. They cannot remarry and update. They cannot disinherit a child who turned hostile. They cannot respond to new family realities. The dead spouse's wishes have effectively locked the surviving spouse into a particular plan forever. The case of Mr. Aristides Sutton and Mrs. Cordelia Sutton illustrates this. Both in their early 60s when they made their joint will in 2010, they went to a family attorney in a small town who accepted to draft the joint document, probably without fully explaining the consequences. They sat together, they drafted together, they signed together. They left the office believing they had handled their estate planning together in a single document. 13 years later, Mr. Sutton passed. The will was admitted to probate. Mrs. Sutton, now widowed, wanted to revise her own portion of the document because their adult granddaughter had become her primary caregiver, and she wanted to recognize that. Her attorney pulled the joint will and explained the contractual element. The dispositions were locked. Any attempt to change them now would be subject to a breach of contract claim by the original beneficiaries listed in the joint document, who were the children of the first marriage. Mrs. Sutton spent the rest of her life unable to update what she had signed 13 years earlier. The granddaughter who cared for her in her final years received nothing under the will. The contractual nature of the joint document had effectively frozen her legal capacity to dispose of her own assets. And here is what pains me most. That couple, in 2010, believed they had done the most responsible act of their lives. They had no idea the document had locked them into a permanent contract. For 13 years, they believed the paper in the drawer protected them. By the time the consequences became visible, Mr. Sutton was already gone. There was no longer any way to fix it. The rule is simple and requires discipline against natural impulse. Even if both spouses have identical intent, even if it feels more meaningful to sign together, each spouse executes a separate will, on a separate date, in a separate document. The intent can be coordinated. The documents must remain individual. I will leave one final technical observation. In the United States, a comprehensive estate plan drafted by a licensed estate attorney typically costs between $500 and $3,000 depending on complexity. A contested probate matter, litigated through the appellate stage, can cost a family between $50,000 and $300,000 in legal fees and take 3 to 7 years to resolve. The math is simple. You pay the estate attorney now, or you pay the probate court later, usually with the family's piece as the additional cost. 5 mistakes. Mistakes that void wills. To recap, improper execution, undue influence by a beneficiary involved in the logistics, doubtful capacity at the moment of signing, interested witness with a connection to a beneficiary, joint will between spouses creating contractual lock-in. 5 mistakes I watched destroy whole American families during 22 years on the bench. 5 that continue to happen every single day across this country because most people execute wills without proper legal guidance, and the form requirements vary state by state in ways that few testators fully understand. I stepped down from the bench because I understood that issuing a ruling is too late. Issuing a ruling is recording the loss. What makes a difference is preventing the loss before it happens. And in the case of wills, preventing the loss depends on these 5 things I just described. I performed a mental exercise in my final years on the bench. I looked at the cases on my docket and tried to estimate how many would have been avoided if the testator had executed a properly drafted will with the 5 precautions I described. The answer was above 80%. 8 out of every 10 disputes that consumed years of American probate court time could have been prevented by an afternoon at an attorney's office, 10 or 15 years before the death. That number is what motivated me to speak publicly. If you listened all the way through, I thank you for your time. This video is free, and the only way I can know whether it is reaching the right people is the engagement of those who made it to the end. Subscribe to the channel, comment, share with at least one person in your family who is over 60 or who is thinking about making a will. That gesture might prevent a fight that lasts years in probate court. And if you have a story about a will that caused conflict in your family, write it in the comments. I read all of them. Each story helps me better understand where the system is still failing and gives me material for the next videos. Take care of yourselves and take care of the people you love. If this conversation reached you before the signature, it has done its job.